Hello, everyone. On behalf of your state associations for private, nonprofit higher education, and on behalf of the coalition, I'd like to welcome you to this webinar on Title IX. As you know, it's a summary of the U.S. Department of Education's recently released draft regulations. My name is Lyon Cruz. I'm the president of the coalition. In a few moments, we'll be joined by Joseph Storch and other colleagues from Grand River Solutions. Grand River Solutions specializes in providing Title IX equity, student conduct, DEI, and Clery Act support services. Many of you already use Grand River Solutions, and they come very highly recommended by many of our state associations. Today, it's actually my pleasure, and I'm really excited to announce that the coalition and Grand River Solutions have partnered to offer a collaborative agreement to our member campuses. Now, this agreement will offer preferred pricing and exclusive services to you as members of your state association. More information on this great opportunity is going to be provided in the coming days and weeks, so please look for it. But now for today's webinar, it's my pleasure to turn the microphone over to Joseph Storch, Senior Director of Compliance and Innovative Solutions for Grand River Solutions. Joseph.
Well, thank you, Lyon, and thank you to you and to Anita and to all of your state association colleagues who we've had the privilege of getting to know and to work with. We are so excited to work with the coalition and to work with the nearly 1,000 schools that the coalition works with. And we are so excited to welcome all of you here today. So to get us started, please welcome my colleague, Laura Figueiredo, who is going to kick us off. Laura?
Thanks so much, Joe. And thank you, Lyon, for an incredible introduction. You did about half of my job for me, and I really appreciate that. Some quick housekeeping notes for today's webinar. If you have any technical difficulties or questions throughout the day, please feel free to enter your questions in the chat box as we'll be monitoring that. Feel free to also unmute yourself and ask your question that way. We really appreciate participation in our sessions. We are also, as you heard, recording today's webinar, and we will be sending you a copy of the slides as well as a link to the recording, which will be available to view for up to 60 days from today. Lastly, live transcription is turned on for today's session, and you can view or minimize your closed caption settings on your Zoom control bar. And before I tell you a little bit more about our incredible facilitators, I wanted to say a little bit more about Grand River Solutions, who we are and what we do. At Grand River, equity is at the heart of all of our work. Grand River Solutions is a mission-driven organization founded with a vision of creating safe and equitable spaces for both the classroom as well as the workplace. To that end, we provide Title IX and equity consulting services to campuses and communities across the country. Grand River has an expansive suite of compliant, creative, and cost-effective solutions to help schools meet their needs in innovative ways. And if you're interested in learning some more about our offerings, please feel free to reach out. And with that, I'd like to introduce you to our presenters for the day. First up, we are joined by Joseph Storch, Grand River Solutions Senior Director of Compliance and Innovation Solutions. Joe is a nationally recognized thought leader on the Clery Act, Title IX, student affairs, and due and fair process. Joe has also trained thousands of higher education professionals across the country and served as a trusted expert for federal and state legislatures and staff. An expert on the overlap of federal and state laws covering harassment and violence on college campuses, Joe has provided over 700 digital and live conference presentations and training sessions to tens of thousands of higher ed professionals in 30 US states. We are also joined by my colleague, Andrea Stagg, who is the Director of Consulting Services at Grand River, where she oversees Title IX and equity support, audits and compliance reviews, athletics, consulting, accessibility and disability compliance, DEI initiatives, and Clery Act compliance solutions. Andrea has extensive experience in higher education in-house legal settings at public and private colleges and universities. She has published legal and compliance writing about sexual and interpersonal violence prevention and response, the Clery Act, NCAA compliance, and program integrity. She is a nationally sought-after presenter and has advised federal and state legislators on best practices in campus safety and sexual harassment prevention. Andrea is a recipient of the Commissioner's Award from the State University Police, as well as the First Decade Award from the National Association of College and University Attorneys. And with that, I have the pleasure and privilege of turning it over to Joe and Andrea for the day.
Excellent. Thank you, Laura. And so excited to be here with all of you from across the United States in dozens and dozens of states, as well as my amazing colleague, Andrea Stagg, who has deep experience in Title IX, as one of the leading voices on complying with the current regulations and looking to the new ones. And we are excited to get started. As we get started, just a reminder, everything we're talking about today is proposed. These are ideas. They may be finalized, they may not, or they may change a little bit or markedly before they are finalized. So nothing we are talking about is current in terms of what are the obligations right now. The only thing, literally the only thing that an institution or institutional personnel have to do right now, if they want to, is submit a comment to the United States Department of Education. We'll have a few beats on that towards the end. But right now, what these are is proposed. So we're making sure we're not telling you to change policies. This is for something that's down the line. We're going to talk a little bit about the scope of Title IX as it would change under these proposed rules, some of the differences in definitions, some broad, some a bit more nuanced, changes in procedure that I think folks might feel are moving back to what some refer to as classic Title IX, and a few more things, because there are quite a few things hidden in the 701 pages of proposed regulations that the Department of Education issued. So Andrea, can you take us through a bit of the history? You have done so much writing and so much speaking across the country about some of this history, and kind of give us the brackets of where we are.
Absolutely. Thanks, Joe, and good to see everyone here today. So I'm glad for all of those who are joining us live and those who will be watching the recording, because right now they're in move-in and all kinds of other things. The end of August here. So this is just the history of Title IX, and it's going to keep going, and then we're going to have to get a wider slide. So, but what do we have? It was just the 50th anniversary. So 1972, Title IX passes, and a lot of things that we consider obvious today, or that seem quaint today, were new from case law in that first half of the timeline, right? So we had the Cannon case where the Supreme Court said there's a private right of action under Title IX. It wasn't clear in the beginning. It wasn't clear in 1973 through 9 that a student could sue and have their own private right of action to sue a school under Title IX. And a lot of these cases that you see here are K through 12 cases, but remember that Title IX applies both to K-12 and higher ed, although you will often see in the guidance and in the regulations some distinction. So post-secondary is going to do this, elementary and secondary are going to do that. And I say elementary and secondary separately, partly because the proposed rules actually define those separately for reasons that we don't need to get into for this crowd, but you might notice it when you decide you're going to read the whole thing if you choose to. The Franklin case was a sexual harassment claim by a student against a teacher. And that's where the Supreme Court said, you know what, a plaintiff can get monetary damages. That wasn't a given before 1992. So all of these things that seem so obvious now, we hear about these big decisions, we hear about these big payouts and student plaintiffs and employee plaintiffs. That wasn't clear when the law first passed that was going to be the case. And the Gebser case is important, and sort of you'll be called back to it as we talk about scope today, because that's where the Supreme Court said educational institutions can't be held liable if they didn't have direct knowledge and then fail to act. So you really need to know, and we've gone back and forth over the years through these other guidance documents and regulations that are listed about what that means and whose knowledge is enough to be considered school knowledge or college knowledge. So that's something that that's still evolving, and it's changing from the current regulations to the proposed. So, a lot of these concepts make a lot of sense now, but were surprising at the time. And, I'm sure that some of the things that seem new today or in 2020 will seem, commonplace 10 years from now as well. Anything you want to add, Joe?
No, thank you. And the only thing to sort of add is on the back end of the slide where, even as there was significant case law happening, it was happening pretty slowly for the first 25 years of the law. And the last 11 years, we have seen a rapid acceleration in changes in litigation in this space, in changes in congressional interest. It used to be that Andrea and I could read everything that was coming out about Title IX as a side part of our work. Now there is so much coming out at all times. It has really rapidly expanded, and we spend a lot of time thinking about how to maybe take some of that heat off, because one of the things that we are afraid of is every 4 or 8 years, as the White House changes, Title IX changing. Many of you have heard it described as a pendulum swinging back and forth. And, it gets hard for folks to grab onto a pendulum that's swinging so wildly. And when it's civil rights, you want things like Title VII, which changes very, very rarely, rather than Title IX, which in the last decade is changing quite a bit.
And anyone doing this work for 10 or more years remembers that when the Obama era guidance came out, it was a real shift. And even though since then a lot has changed in regulation and in guidance documents being rescinded, for a lot of schools they didn't unring that bell. So once you've created a heightened obligation and response and prevention efforts on your campus, many schools did not then tamp that down when the regulations changed. It became their policy decision instead of by regulation, and we're going to see that that's going to be changing here. But it's worth mentioning because it may be that not that much changes at your institution, except for what you consider being Title IX prohibited conduct, which where right now so many institutions have 2 procedures, one for Title IX prohibited conduct and one for non-Title IX prohibited conduct. That's still sexual misconduct or sex and gender-based discrimination and harassment. And so it may be that you can combine those, or at least the scope of the Title IX one becomes wider, as we'll get into.
And so, Andrea, it was no surprise to anyone that the Biden administration would be putting out new regulations. Then candidate Joseph Biden had decried the May of 2020 regulations on the day it came out. So that was expected. There had been an executive order saying that, ordering the Department of Education to look at that. And so June 23rd, 50th anniversary, here we go.
And we saw them June 23rd unofficially, published officially July 12th. And the reason why that matters, unofficial versus official, is because the comment period starts with the official publication in the Federal Register. And I think it took a little longer than the Department of Education anticipated, because I remember that Suzanne Goldberg from the Department of Education did a webinar, and she mentioned that they were hopeful it would come out the 8th. July 8th, but they didn't. It didn't come out till the 12th. So once it's published on the 12th, that gave us the comment period to September 12th. We were hoping, and we were saying, a month ago, 2 months ago, we hope that this is extended, and it hasn't been, at least not yet. So it's not too late. The Department of Education, if they're watching this, could decide that they would like to extend the comment period a little bit, considering that September 12th is so early in the fall semester for so many of our institutions. When a lot is going on, they haven't had time to maybe meet with different stakeholders and constituents on campus and in their community to talk about what they want to put in a comment. But to date, they have not extended it. So it's still September 12th as far as the comment period goes. We know that the last comment period, which was only November to January, took almost a year and a half for the department to come out with the final regulations. That we know they had over 124,000 comments. There are a lot of comments right now. I haven't checked today. I don't know if you have, Joe. I checked just the other day. There were about 102 or something thousand comments, and only 20-something thousand posted online. So you couldn't read every comment online. Part of that was because some of them were redundant. Maybe they were the same sort of form letter. Some of them might have had personally identifiable information. So those are some of the reasons why you won't see every single comment posted. But the department, whether we can read all the comments or not, the department has to. So the Department of Education is required to read every comment and address it somehow in the final regulations. And that's why the preamble may end up being thousands of pages long.
Yeah, we expect, if the last preamble was 2033, we should expect something in that neighborhood. And frankly, it took me weeks, maybe months, just to read the whole thing last time around. And so there's quite a bit put in there. Now, the 2020 final rule, the one that's effective now, as compared to how we thought about Title IX before that, did quite a bit of narrowing in a number of areas and expanding in one area. So we saw a narrowing in what types of behavior would be actionable under Title IX, or at least investigatable under Title IX, in where within a program or activity, and certain off-campus student organizations, in how it would get into the process, right, through a formal complaint or through a complaint filed by the Title IX coordinator, and some significant narrowing in how things would get into the process. We did see a significant widening in due process. In some places, that came from some case law. There was a Sixth Circuit case, Doe v. Baum, that in a 2-to-1 decision had applied for the 4 states in the Sixth Circuit a requirement that cross-examination be live and direct by the advisor of choice. That was adopted into the proposed and then final regulations in 2020, and a very prescribed set of due process obligations. And due process is a funny term to use in Title IX rules that apply to public and private colleges. I spent a decade and a half working in public higher education, was very used to due process. Andrea split her career between public and private higher education. In one place, she would work a lot on due process. In another place, she would work on fair process. But here we saw an application of due process to public and private colleges alike. But Andrea, the 2022 proposed regulations, finalized in 2023 or 2024, would see some significant changes. And I think the biggest one is sort of scope of what would count.
Absolutely. So right now, under the current regulations, there's mandatory dismissal of a formal complaint if it's out of scope. And I mean scope in a few ways. I mean geography. So the incident that's underlying the complaint did not occur in an educational program or activity. And there's more to be said there about sort of, it doesn't have to be on campus, as long as if it's related to the program or activity, which may have taken place at another location, as long as that location was in the United States. So if it was on your campus in Rome, even though it's all your employees and you own that land and those buildings, no, outside the United States, mandatory dismissal under the current regulations. And also sort of a narrow set of violations with really high standards about who the misconduct was reported to, whose knowledge imputes knowledge to the institution. And that process is only for certain types of violations. So not every kind of sex discrimination gets this full process that was developed. In the 2020 regulations, it's only this narrow set of sexual harassment and violence that is also at a standard that's different from what some of us were used to, particularly in the employment setting, as far as what creates a hostile environment. And we'll get into those details. So it is a more significant process. So there's some things that are changed and some things that are not as much of a change yet. Although we don't know exactly what the final will look like. Usually the final regulations look a lot like the proposed. That's just the way that it's gone, right? They look a lot like the proposed, although there could be a couple things that end up being a little bit different. So this slide shows one of the proposed expanded scope here. So there's some stuff that's the same, right? So there's sex-based harassment includes quid pro quo, that's the same. Hostile environment, generally the same. That sounds the same until you get to what that means. So for the current regulations, hostile environment, we're talking about severe, pervasive, and objectively offensive conduct. Here in the proposed rules, it's severe or pervasive. So we're going back to or, which is where we were pre-2020 regulations, Obama era guidance and before, which is where we are in the context of other civil rights laws when we talk about what constitutes a hostile work environment, or here a learning environment. So we're getting back to or, which people have been used to and maybe have been using for that non-Title IX prohibited conduct column. And then the same with the specific offenses, and I would call those the VAWA crimes, sexual and interpersonal violence crimes, sexual assault, domestic violence, dating violence, and stalking. So that's in the current regulations, it's in the proposed, that stays the same. Then we get this other second category, which the 2020 regulations do not address at all, which is discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, and they define what that means, sexual orientation, and gender identity. And the preamble discusses some recent case law behind adding some of these, and it's consistent with some of the guidance documents from the Obama era that were rescinded when the Trump administration came into their leadership at the Department of Education. So some of it is new, but not surprising, and in line with what we'd seen in previous guidance. And that's something to note here, is that these are regulations. What we had in the Obama era was guidance, and guidance is really easy to take away, right? Guidance giveth, guidance taken away. It's as simple as sending a dear colleague letter saying this has been rescinded, or maybe even not even sending that letter, just putting in red at the top, this has been archived, this is rescinded, archival purposes only, right? And you see that appearing on every page of these documents. You can still access those rescinded documents, but they have sort of a disclaimer at the top, this has been rescinded, do not rely on this. So here, putting this in regulation makes it a lot harder to undo. We know regulations are hard to change because here we are, it's August 2022, right? Almost 2 years since the presidential election, and we finally are closing in on the end of the comment period for the proposed regulations. It took a really long time, and by the time they're finalized and then implemented, we're heading toward another election.
And Andrea, a practice point, you and I have been privileged to go around and talk to a lot of Title IX offices, a lot of student affairs offices, conduct offices, and I think we saw in 2020 a narrowing of the role, or the primary role, of many Title IX offices to just addressing sexual harassment, sexual and interpersonal violence in a way that may have pushed some of these other areas that are not new, right? Pregnancy and related discrimination, pay discrimination, equitable pay discrimination, athletics. They're not new. We're not hearing about them for the first time, but welcome back, I guess, to this regulated space that folks are paying so much attention to.
Yeah, I mean, you're right. They're not new to the regulations. When you look at the full regulations, not the 2020 changes and additions, which is the full regulations, you see plenty about pregnancy and parenting, but it's just that it was ignored in the past 10 years, right? Because the Obama era guidance was hyper focused on peer sexual violence, which I understand. There were reports coming out of White House commissions. They had the CDC on the case that this is a public health issue and it's plaguing our campuses, and we need to do something, and we need to be talking about this. We need to give guidance, and people need to make changes. And there was all kinds of, that was what OCR was tasked with for their enforcement agenda, right? But we weren't hearing a lot about these other kinds of Title IX potential violations and investigations, because it just wasn't on the enforcement agenda in a way that was publicized. It doesn't mean those investigations didn't occur, but they weren't published with a press release from the department. So, we are seeing more explicit information about pregnancy and related conditions, retaliation and peer retaliation. I mean, I don't know an institution that wasn't considering peer retaliation as prohibited retaliation, but the department wants to make it crystal clear in these regulations. They put in everything they could to be as clear as possible so that people didn't have to assume, right? When we say retaliation, we don't just mean by the institution against a party or witness or participant in this process. We mean you also must prohibit peer retaliation and respond to complaints of peer retaliation, and let people know how to report peer retaliation and have a process that you investigate it and address it, right? All of those things. And the expanded responsibility is what we're talking about. Is there's more now that schools will be responsible to act on, and more people are responsible for taking some sort of action. And we'll get to that, a little bit later.
So I want to dive into one of the areas, which is the response of the institution, right? You were talking about some of the case law from the 1990s, and for quite a while, right, 20 plus years, there had been quite a bit higher level to get relief in a courtroom than to get relief from the Office for Civil Rights. The 2020 final rule sort of brought those quite a bit closer together in saying that an institution just has to be not deliberately indifferent. As expected, the Biden administration would really move off of that standard, not for court findings. That's not what's at stake here. That is still good law, but for these administrative determinations.
Yes, and so the standard that they are talking about will sound familiar to anyone who is doing this work during the Obama era and beforehand. This language goes back to previous guidance dating, to the early 2000s, maybe even the 1997 guidance, which is that when you learn about sex discrimination, you need to, as an institution, you need to end the discrimination, prevent it, and remedy the effects, right? You need to be taking actions to try to end it, prevent it, and remedy the effects. And we saw this in the Obama era guidance, over and over. We're seeing it in these regulations, but that's ending, preventing, and remedying the effects is different from respond promptly in a way that's not deliberately indifferent. It's a much higher standard. And it's not only that you need to act in those ways to end, prevent, and remedy the effects of sex discrimination that you learned about, but also you need to document that you did that, because sometimes these complaints come up later and you're not sure who said what or did what and how prompt it was. So, all of that is important. So it's not that institutions weren't acting in a way that would meet these standards before, but they need to make sure, you need to make sure that you're documenting the steps that you took, right, to end, prevent, and remedy the effects of reported and known sex discrimination and harassment, so that you can document that you met the standard.
And pregnancy and parenting is not something that in and of itself is new to Title IX. That language has been around for a while, but a couple of new nuances, right? Having a clean location in which to allow folks to express milk, having some other provisions that we make sure are accessible, and some other areas around that. One of the ones that I know you like talking about, and this is something folks can start working on right now, is how do we ask honorifics or titles when folks are applying for a job, applying for admission, they want to do a program or activity. Are we asking Mrs.? Are we asking Miss? Are we asking Ms. And the like? This is something folks can work on right now.
Absolutely, and that's related to the prohibition on asking for marital status pre-employment or pre-admission. And the department's much more clear about that prohibition in these proposed rules. And anyone who has placed for title in their applications, whether that's for admission or for employment, there are two separate sections in the proposed rules, one for admission, one for admission, and one for employment. But they say the same thing, which is you can't ask for marital status and make decisions based on that.
One of the other areas of some significant changes that we will see in the 2022 proposed regulations when they become finalized is the inclusion of sexual orientation and gender identity in terms of what an institution cannot discriminate on the basis of sex. And in some ways, this feels standard, right? People say, well, isn't this the case already? We saw a Supreme Court case in the summer of 2021, Bostock, and there were a couple of other cases where the Supreme Court said for Title VII, right, for employment purposes, to discriminate against somebody based on who they are attracted to, based on their gender identity, is to discriminate against them on the basis of sex. And we've seen cases that have gone up in the Fourth Circuit and the Seventh Circuit and all across the country that have really addressed sexual orientation and gender identity on the same level as sex. So in some ways, it feels like, wait, isn't this the case? But if you look at the 2020 final rule, again, pre the determination in Bostock, it specifically does not include, it specifically declines to include sexual orientation and gender identity within the category of discrimination on the basis of sex. And here we see that inclusion. And folks have to remember that it was not that long ago that this kind of language would have been unthinkable in these rules from the federal regulations. Andrea and I were privileged to work in New York State on Education Law 129B, which had among its many, many sentences, a single sentence that said the standards of this right apply regardless of sex, gender, sexual orientation, and gender identity and expression. And when that was signed into law in July of 2015, it was the first law anywhere in the United States that provided equal rights on the basis of gender identity. So we're not talking about many, many decades ago. We're talking about a significant amount of changes in just the last 7 years. So of course, we have the application within sexual harassment, sexual and interpersonal violence. If someone is a victim of violence or harassment on the basis of sexual orientation or gender identity, that would be treated equal to, equivalent to, on the basis of sex as understood for the last 50 years and 2 months. But we also have a requirement that we treat folks equally, regardless of sexual orientation and gender identity, across our education programs and activities. So we're using on the slide the term LGBTQI+. That is the term that is used in the regulations. We do acknowledge that folks include other letters in that. We're just including exactly as our regulators do in their language. But this is something that it's frankly amazing for those of us who've done a lot of research and scholarship and training in this area, feels so standard, but yet is so unbelievably different than it would have been not even a decade ago. And we will see this. Now, what did the department not do? The department specifically did not address athletics and said that it would address athletics. This is something that a lot of folks have been talking about. There have been quite a number of news stories and folks writing about on different sides. The department, I think, probably determined it's too much to include here, that maybe they weren't done and they didn't want to hold up all of this other work for that. So we will see a separate rulemaking around athletics, but I don't see a reason to believe that the regulations as proposed would not apply to things like providing access to bathrooms, housing, and the like. So that is something that we will want to watch and that folks will want to think about and be prepared for. Andrea, anything?
Yeah, so the preamble does not talk about pronouns, does not talk about names and misgendering. It's a lot of some of the questions we've gotten from others, and do feel free to put questions in the chat because I'm noticing there aren't any, which I'm surprised because usually this is where people say, "What happens? Is it clear that it's a Title IX violation if a faculty member, misgenders someone or uses the wrong pronoun or something like that?" So they don't talk about it, and I think that that's a gap that may be addressed in a response to questions in the final rule preamble and discussion. But they do say that they talk about different treatment or separation based on sex. So sex separate facilities and sex separate activities. And it says that you can have a policy of sex, you can have sex separate activities and sex separate facilities like men's and women's bathrooms or something like that, so long as it doesn't cause more than de minimis harm or more than minimal or trivial harm. And the department goes on in the preamble and I think in the regulation itself repeats that engaging in a practice or policy that prevents someone from participating in an educational program or activity, including the provision of facilities and groups and activities like that, consistent with that person's gender identity, subjects that person to more than de minimis harm or more than trivial harm. So what they're saying is you can't do sex separation if it causes in a way that causes more than de minimis harm. And by the way, keeping someone from participating consistent with their gender identity does cause more than de minimis harm. So you can't do sex separation in that way that keeps someone from participating consistent with their gender identity. So for states, and they don't say the words locker room, bathroom. They mention facilities only in referring to another document, another regulation about which says you're allowed to have separate bathrooms for men and women. You're allowed to have sex separate facilities, for example, showers, toilets, changing rooms. So they refer to that piece of the regulation that allows that, but they don't talk about what this means, what this guidance means here under these regulations. And they don't talk about what this regulation will mean in states where state law says you can't allow someone to use those facilities consistent with their gender identity. And it would be a crime to allow someone to use a facility like that consistent with their gender identity. So that's, I have no doubt that folks in those states and those AGs are going to be commenting and suing about that particular section. That's 106.31A2. If you'd like to take a look later, write it down for
So
later.
following along at home.
Anyone following along at home, but it's, I think a lot of people when they hear, okay, sex separate is okay as long as people can be consistent with their gender identity. And if you're in a state where that's the state law or the city law, no, like Joe said, no problem. But if you're in a state where that's prohibited, you really want the department to be crystal clear about what they're requiring in order for the federal regulation to trump the existing state law.
So who has an obligation to respond would change quite a bit, right? So under our current regulations, right, we have the Title IX coordinator and we have officials with authority to be able to redress sex discrimination, sexual harassment, sexual and interpersonal violence. A pretty small group, right? You could fit them into a lounge on campus pretty easily. The 2022 proposed regulations would spread that responsibility across essentially everyone on a college campus, every employee at least on a college campus, and quite a number of student employees as well. You would have a number of different statuses, right? So you'd have the status of folks who work in the Title IX office. They would have one status and they'd have an obligation, right? You would have those who could take action to redress grievance and they would have an obligation. You would have folks who have true confidentiality and they would not have to bring forward the information, but they would have to let the reporting victim know how to access the Title IX office. And this is Andrea loves this graphic. It makes me want to take Advil and take a nap. But
it's a map. It's a map.
Right. You have a number of other folks on campus who would have different obligations. So I'll give it over to Andrea and go take my Advil.
Okay, and that's fine. And it's this is a map, just so when you find out, okay, our part-time elevator repair person who is somehow on your payroll and your employee and not a vendor, somehow you've decided your elevators break down enough that you're going to employ this person. They learn about sex discrimination. What do they need to know? So we can go through it, right? And you're going to get the slides, so there's no reason to panic. Is the employee confidential? No. Do they have the authority to institute corrective measures? Only with elevators, so no. Does the employee have the responsibility for administrative leadership, teaching, or advising? No. They have two options, and neither of them is do nothing, right? Report to the Title IX coordinator, or give the Title IX coordinator's contact information and information about how to report sex discrimination to the person who provided them with the information about this conduct, right? Which may or may not be the person who experienced the conduct. It could be someone else who's just sharing, like, I heard this from someone, or someone reported this to me and they don't want to tell the college, but I think it's really important. So that part-time elevator repair person has to do one of these two things according to these proposed rules. And I think the department's going to get a lot of feedback from that. And the important thing to know here that this is a really big change from where we are now. Where we are now is if these certain designated people who can take action, so you're talking about your student conduct, student life office, your HR office, your Title IX coordinator and personnel, if someone tells them, that triggers the college's obligation to have to, respond. But if it's any other employee, they either need to report it to the Title IX coordinator, triggering the obligation to respond, or give that person who shared the information with them contact information for the Title IX coordinator and information about how to report. That's a lot. That's a lot of obligation for a lot of people. If you're talking about a large school with tens of thousands of employees, that's a lot of people who have you on the hook for response.
And the modal elevator repair type employee will receive 0 disclosures across their career. So not only do we have to train them once, we have to figure out a cadence on how to train them so they remember it, because that elevator repair person 25 years after their training will still have that obligation, even though that report they receive in their 25th year may be the first one, right? We often think about, oh, the Title IX coordinator, the VP for Student Affairs, the Dean of Students. Yeah, they're having these conversations with students on a regular basis. This is going to spread some obligation to folks who will almost certainly never directly receive a disclosure, but have to be ready to act appropriately when they do.
And we got a couple questions, and one that we can definitely answer now from David about, is it, as it's currently written, is it required that we give the part-time elevator repair person information that they can do those options, or can we determine whether we want them to refer to us? As written now, there's no obligation for this part-time elevator repair person, right? Unless it's by policy. So the institution can decide, totally up to you, every single person who receives a paycheck from us is a mandatory reporter. Here's what that means. But it's totally up to the institution. The Department of Education says, we leave that to you. We're only saying, as the Department of Education, that these folks who have, authority to address complaints, the people, sort of the usual suspects, that they trigger your knowledge as a college and your obligation to respond. But other people, no, we don't expect that all of these other employees who are not, day to day interacting with students, advising, any of those things, we don't expect them. Their knowledge doesn't trigger college knowledge.
So one of the other areas that we are seeing is an expanded scope geographically. The current regulations are limited inside the United States to programs and activities, and the Department of Education would actually change the focus quite a bit. And this will feel more familiar to those who are familiar with 2011 and with the 2001, 1997 approach, but certainly the 2011 and 2014 approach, which is to change it to, rather than the obligation coming on based on the geographic location that the incident occurs, the obligation to redress sex discrimination would come from based on where the impact of that harm is. And so that's something that makes sense, right? Makes sense in a lot of ways. Title IX is not the Clery Act. Title IX is different than the Clery Act, and in some ways they were moved closer together, but like tectonic plates that never quite align and are always scraping against each other. They were never really aligned, even in 2020. And Andrea, I think we'd be moving back to a classic approach. And my interest is this an approach that's here to stay, or is this something that's going to go back and forth? If there's a certain party in the White House, it's going to be where the incident occurred. If there's another party, it's going to be where the impact occurs.
I was shocked when we made the change that we did, right, in 2020, because institutions have always cared about how people behave when they're off campus, especially when you have a very decentralized campus or a non-residential campus or a large population of the campus that doesn't live in residence halls. We absolutely care about student conduct that occurs a block from campus. So I think long term, it's the who and not where for response and prevention.
So Andrea, we saw a new term in 2020, supportive measures, right? We used to talk about accommodations or resources, and those were really pulled into the term supportive measures by the Department of Education. But the department said you can't offer something as a supportive measure, which could be a sanction. And so we had to really divide in the world between things like a suspension that could be a sanction, and a suspension was something that conduct and Title IX and HR folks were fairly used to as one of the tools to kind of keep things steady while an investigation and a process continues. Andrea and I both have spent time doing employment law. Certainly that is something that happens in employment law when there is a certain level of behavior. It happens in all sorts of student conduct cases. Our colleague Martha, who just commented, was the prior president of the ASCA, and she has spent many times talking about, and indeed in her work before, suspending students who committed grave offenses, violence, hazing, and the like. It was something we were used to, and that was taken away as a tool because we had to have this separation. That is no longer the case under the proposed regulations. So the supportive measures, to my reading, are fairly similar, pretty similar to what we have in 2020, but I see that as a big change. Andrea, do you see any other sort of big things on supportive measures to mention?
I think even though not that much change with it, the department wants to talk about it again. And that's what we're finding in these. That's why the preamble is as long as it is, because even where something isn't changing much, they want to talk about it. Or even when something is sort of presumed and is the reality from 2020, they want to make sure that it's discussed. And we thought about this and we're talking about it and we're clarifying by adding a few new words or a new sentence or moving, even just moving a section from one place to another for more clarity. So they really went to town on this. So I think they just wanted to show, like, we're thinking about supportive measures. Those are really important, and making crystal clear that people can access them regardless of whether they file a formal complaint, whatever that may mean.
So informal resolution was an area of concern, I guess I would say, for the Obama administration, and certain types of informal resolution were even prohibited in cases of sexual assault. That those prohibitions were lifted entirely by the Trump administration in the 2020 final rule, but there was this one little hook about informal resolution, which is you couldn't even start it until after the formal complaint has started. You had entered the formal process, then you sort of take an exit ramp to the informal process. Not so much with these proposed regulations.
Right. These proposed regulations say you can have an informal resolution start without a signed formal complaint. And generally that's a good thing, I think. And noteworthy is that having a formal complaint sort of kickstarts a record keeping procedure. For many institutions, you've got forms, you've got templates, and you have a process. We get the formal complaint. This is what we do. We send these notices. We save everything in this place. And so if an informal resolution doesn't require a formal complaint, just making sure that you have a mechanism to track and document all of that. Which is important. But overall, this is where the department's kind of meeting in the middle. So we had the Obama era, like sort of, saying in certain instances, no informal resolution. And we had, the 2020 regulations, like, informal resolution for all, but using this formal complaint process, which itself can be a barrier to folks who would want to engage in informal resolution. And now we're sort of meeting back in the middle.
So let's talk about formal resolution, because here is where I think we're seeing the most change on the substance. So the 2020 final rule is very specific about the requirements for formal resolution of these types of sexual and interpersonal violence, sexual harassment disclosures. There is a bar on the use of what's sometimes called the single investigator or the single investigator hybrid model. There is a requirement that all institutions of higher education, and as Andrea mentioned earlier, we're not talking K-12 today. If you have a dual role, we have a session in September you could come to. That's not the content today. What we're talking about is for the higher ed, there must be a hearing. That hearing must include direct live cross-examination, Sixth Circuit style cross-examination, even as other circuits across the country, the First Circuit here in the Northeast and another circuit just a couple of weeks ago declined to adopt that. And we would see a significant change to the approach in the amount of process. So Andrea, do you want to sort of take us through some of those things and we can discuss them?
Yeah, and some of them, are not quite clear to us and ripe for comment for the department if anyone's thinking about doing that. So Live here, and remember, and I know Martha said it too, I'm going to say it again, we are talking about federal law here. You may be in a state that has rules about live hearings, cross-examination, and who does it. So you need to follow, the federal law might be setting a floor here, and when it permits something that your state law requires, you've got to follow your state law, right? So just to say that, because it's important for these things. The Department of Education is saying live hearing, it's up to you. Like, if you want to keep having them, great. If you don't, that's fine too. So if you're at a private institution in a state or a circuit that doesn't require live hearings, then you might get rid of that. And, I know we said in the beginning, there's nothing you have to do now, and that's true, but nothing to do, but you can do some thinking, right? And people can be meeting and thinking about, hey, if this goes final as proposed and doesn't get bogged down in litigation, right? Let's say it becomes effective in our lifetime before retirement. Are we going to keep live hearings or are we not? Right? You can have that. You can start having that conversation this year. And I know I have campus clients who will say, no, let's just delete that shadow procedure that we created. Right? We haven't used it much. It doesn't work for us. We didn't use it before, and we only did it because we had to from 2020. There is the right to an advisor of choice, which remains. It's a little bit different because it does seem like, well, depending again what state you're in and what circuit you're in, the Department of Education seems to be giving a choice about whether the cross-examination needs to be from the advisor, the actual party's advisors, or that the questions could be through a hearing panel or board chair. So that's also a little bit unclear from the way the regulations are worded. But in the beginning, I thought, okay, we're still like, if you have a live hearing, you have to have advisor cross. It's not totally clear. You have to have a credibility assessment mechanism, and one of those is advisor cross. But there's also an alternative, even during a live hearing, that the way that I'm reading it at this point, which wasn't the same way I was reading it on June 23rd, that you can also ask questions through the decision maker or hearing officer to get that credibility assessment. Of course, those questions would be coming from the parties and their advisors, but it wouldn't be direct, again, depending on which state you're in. So that's a change. Right now, there's not a lot of flexibility in this area. Like the procedure is what it is. And so this is a little bit different. Standard of evidence, again, we thought this was going to go way back to Obama era, and it didn't. Again, we're kind of going halfway back. So the Obama era was like preponderance of the evidence, always, no matter what. You cannot use anything else, right? So it was very clear, like when you were doing your compliance checklist with the Obama era guidance, one of the elements, of course, that the department would be looking at if you had an Office for Civil Rights investigation or review was, what is your stated published standard of evidence? And if it wasn't preponderance, they would have a problem with that, and that would come up. So that was for sure. And then 2020, there was a clear preference for the giving flexibility. Like you could use preponderance, you could use clear and convincing, and here are the instances where this is how you would decide what you use. If you use clear and convincing, you use it for everything, right? And so that was a way that schools were determining which one they're going to use. Here, we still have flexibility in these proposed rules, which I think was a surprise to me. I thought we were going to go back to preponderance is the only one that's permitted. So the standard of evidence here is preponderance, but clear and convincing is permitted if you use clear and convincing for comparable proceedings. Not required if you use it for comparable proceedings, which would make, you can make an argument that equitably that would make more sense, that if you use clear and convincing for everything else, you should use it here. No, permitted by these regulations if you use clear and convincing for everything else, not required. You could still use clear and convincing for everything else, comparable proceedings, and use preponderance in these Title IX cases, which is interesting. What else here?
All sorts of folks are going to need to get training. And what I hope you would do in the next year and a half as we move from proposed to final, I not to look in a crystal ball, I could be completely wrong. My guess is what you see in the training section is what you're going to see in the final, right? That is not what the 102,000 submitted comments so far are about, down with training or, anything like that. You're not going to see a difference there. So thinking about how your institution wants to take this really amazing opportunity to talk to so many different people across your campus, right? So of course, we're going to have a core amount of training for the coordinators, the investigators, the hearing officers and decision makers, the appeals folks, the folks who are advisors that are appointed and the like. We'll have a lot of training for the folks in housing and student affairs and public safety and university police and the like that are really adjacent to the process or part of the process. But there's going to be all sorts of other trainings for all sorts of other folks on your campus. You'll have to do some notification to your students and help them understand the new process. And these are students, if they've been around a while, might have been under 3 different processes during their time in college. And so that is something really to kind of think about, how to clearly communicate where we are, but also all of these other folks. Andrea's example of the part-time elevator repair person all the way up and down the line, making sure that our faculty understand where we are and what our colleges or universities approaches and how that aligns with the moral feelings and the policy feelings of the institution. It's a wonderful opportunity. I hope folks don't look at it as another compliance check the box. We've certainly seen plenty of that across many different spheres, but look at it as a really amazing opportunity to let students and faculty and staff, our community, understand and clearly understand their rights under this pretty critical equity law. So closing out, before we have our Q&A, we will just close out. We'll ask Lion to offer some closing comments. We'll pause the recording and we'll stick around to take your questions and answers. As Andrea said, we have until September 12th. The department may extend it, maybe, who knows? But if you want to get your comment in, the date is September 12th to do so. One of the things we often talk about, I love this Abraham Lincoln line of, I'm so sorry I wrote a long letter, I didn't have time to write a short one. And always when Andrea and I work together on something, I will write way too long and she will cut it way back, and she's always right, except this one time, because as she said earlier, the Department of Education is required to read everything you write. So don't feel like you need to cut it down so it's more readable or more pithy or more tight. Be detailed. Get your institution's opinions and thoughts across. There is no size limit. There is no length limit. To the extent you have something to say, say it. And by the way, say it in the order that the Department of Education has laid out in the regulations. They do want us to respond. So even if pregnancy is the #1 thing that you want to talk about, discrimination on the basis of pregnancy, still do it in the order of the regulations. One little practice point that I like to make is, if you are going to submit them through the portal, which is how you have to submit them, the department has said we are no longer accepting fax submissions, which is great for those of you who are hoping to comment from 1987. That is no longer an option. But you want to make sure that you are submitting it in a way that is OCR'd, optical character recognition, right? Not the Fed OCR, but OCR. So either submit it in the original Word or in a PDF that's print to PDF. Don't print it, have the president sign it, and then scan it in. Not only is it not accessible to those with print disabilities, but the department also cannot cut and paste from it as they like to do. They have some specific requests. Again, Lauda is going to share the slides with you, so you will have all these. But to the extent you have something to say about one of these areas, the department, which welcomes comments on any part of the regulations, has specifically called out that it wants to hear in these areas. So really, that is something to very much concentrate on. What a privilege it has been to be with you today. Let's turn it back over to Lion for some closing remarks, and then we'll stick around and answer questions. Feel free to keep putting those into the chat, or we can come off mute. Lion?
Yes, can you hear me? Awesome, the mic works. Well, Joseph and Andrea, thank you so much for your expertise today. Coming as a former CFO, I wasn't in the midst of Title IX regulations, but my goodness, it is so hard to keep up with compliance and to keep up with the changing the changing rules and regs from the government. I just appreciate people like you all that can read this stuff and can understand it, and that can guide us and direct us on what we need to do in the future. So I would just implore everyone that's attending here and anyone that hears this, please contact Joseph. Contact Grand Rivers. They are the experts. They will answer your questions. I'm sure if it's a small question, they'll do it for free. If it's a bigger issue, then tap into our agreement that we've just signed. Like I said, more information to come out later. But I would also ask if there are any questions lingering out there. Does anybody else have any more questions for Joseph?